I do have a bit of good news that I could share with everyone. Both Matt and John recently welcomed new additions to their families. John welcomed a daughter just a couple of months ago, and Matt just this past weekend welcomed a son. So, even in these times, there are silver linings. And time will only tell whether, when we look back on this time, whether insurance was another silver lining in these otherwise cloudy times. So let me take care of some of the housekeeping matters before we jump into the presentation. Krista, if you could go to slide 2. So the first thing I need to let everybody know that despite some of the brilliant things that we will share with you today, none of it is legal advice and shouldn't be taken as legal advice. In addition, the webinar itself has been approved for 1.5 Pennsylvania CLE credits. To obtain credit for the seminar today, please send an email to marketing@flastergreenberg.com with your CLE ID number, and our marketing department will make sure that you receive credit. We're also recording today's presentation so that, later with family and friends, you can replay this again and again. Again, if you'd like to see the recording, our marketing department will send a link later once the webinar is live on our firm's COVID-19 resource page. Finally, we'll welcome any questions that you may have. To ask a question, simply click on the chat button at the bottom of your screen. We'll try to answer those questions in real time, or certainly at the end of our presentation today. Okay, so with that said, again, my name is Lee Epstein. Been practicing in the insurance coverage space for over 30 years now. At the beginning of my career, I devoted a lot of time to representing corporate insureds seeking insurance in response to massive asbestos and environmental liabilities. In more recent years, I've devoted a lot of time to representing insureds seeking insurance in response to major catastrophes around the country. Hurricane Katrina, Superstorm Sandy, and Hurricane Maria. In the interim, I worked on some one-off matters involving Y2K and the events arising out of 9/11. It remains to be seen whether the insurance coverage disputes and litigation arising out of COVID-19 will last for 30, 40, 50 years, like asbestos and environmental claims, or whether they will fizzle shortly, like those claims arising out of Y2K. Christoph, could you advance the slide, please? Without question, well, let me just preview for you where we're going to go today. I'm going to start off by just putting in context, the circumstances that we're facing today in light of the pandemic. I'll then talk about some general insurance principles, first-party insurance, third-party liability insurance, before doing a deeper dive into business interruption insurance, where a lot of the current action concerning insureds and their insurers is taking place. At that point, I'm going to turn over the proceedings to Matt, who's going to give us a broader discussion on some of the litigation and legislation that has arisen in response to the dramatic business interruption losses that have been suffered. And then finally, John is going to bring us home and talk about some of the liabilities, third-party liabilities that have arisen in response to the pandemic, and what types of insurance could potentially respond to those liabilities. Looking at the chart that we have in front of us here, it's easy to see that the losses we have suffered have been catastrophic. Currently, there's over 38 million cases worldwide with over 1 million deaths. Let me put that into context. When I gave a similar presentation at the end of April, at that time, there were just 3 million global cases and just 200,000 deaths. At this time, the United States has already surpassed that death toll. And we're approaching 8 million cases ourselves. Sometimes, it's easy to lose the forest for the trees. These cases are happening every day and they're getting worse. Next slide, please, Krista. At one point, as you'll recall, 95% of Americans were subject to stay-at-home orders. Even today, I suspect that many of you are still working from home. Quite frankly, I should have mentioned at the outset that if any of you are wearing pajama bottoms, I'm required to tell you that you must keep your video off and/or remain seated at all times. Any violators will be shamed publicly. On a personal note, I don't know if you're like me, I have not eaten a meal inside of a restaurant since March. Next slide, please. The impact on employment and businesses has been devastating. Early on, there were estimates that businesses were in line to lose $431 billion per month. Already, there have been 40 million jobless claims filed. And so, next slide, please. We're here today to talk about how insurance could and might respond to the devastating losses that have been suffered. We're going to talk about first-party insurance as well as third-party liability insurance. And I took a quick look at the list of attendees for today's seminar, and I know many of you are well-versed in these areas and might find some of this to be a little simplistic, but I know that many folks that are participating in today's seminar are not steeped in insurance. So it'll be helpful if I spend just a couple of minutes talking about the basics. First-party insurance is insurance that responds to losses sustained directly by the insured, either to his person or his property. Whereas third-party liability insurance provides coverage in response to claims asserted by third parties who themselves have suffered some sort of damage to their person or their property. And again, for the uninitiated, let me attempt to take these somewhat amorphous concepts and make them a little bit more understandable. Recently, I took over as the president of my college fraternity alumni association. And we own and operate a fraternity house, a small business, if you will. And to protect us and to protect the fraternity, we purchase both first-party property insurance as well as third-party liability insurance. And so, for example, if one of the undergraduate members would take a heavy object and decide to throw it indiscriminately through the hallway, causing a water pipe to burst and some $50,000 in damage. Of course, this would never happen, but if it were to happen, we would look to our first party insurance to respond and cover us for that. If, for example, in light of the coronavirus, as many college campuses got closed down and the fraternity was forced to close down and we lost revenue as a result of that closure, we would look to business interruption insurance to provide coverage in response to that situation. And let's say a guest were to come into the house and contract coronavirus and assert a claim against the fraternity. There we would look to our third-party liability, perhaps general liability insurance, to respond to claims of that sort. Now, irrespective of whether we're talking about first-party insurance or third-party liability insurance, there are some issues that are universal. And I would suggest some of them are the following. The first thing you will want to do if presented with a claim, a loss, a potential liability, is conduct a thorough review of any potentially implicated insurance policy. Very often, more than one type of policy could respond to a single point of loss or liability. Even if multiple forms don't apply, if it's a large loss, for example, you might have coverage under a primary policy, as well as some excess insurance that sits on top of the primary insurance. So you want to make sure in responding to a loss or liability that you have before you all of the potential insurance that could provide a source of recovery. In addition, while there's often some standardization in policy forms, very often there is variation, if only because of endorsements that are added to the policy. So you want to make sure that you conduct a thorough review to make sure you have a full and complete understanding of what is and what is not covered. In addition, most every insurance policy requires prompt notice in response to any potential claim. As a result, you could, an insured could lose or forfeit insurance unless the claim itself is not notified promptly to the insurance company. All of this suggests that in response to at least a significant claim, loss, or liability, it would make sense to consult with an expert in the area. And I know many of them are participating in the presentation today, whether it be an insurance broker, a public adjuster, a forensic accountant, or even a lawyer. And I often analogize to a situation where if you have a heart condition, you're not going to stop at seeing your general practitioner. You're going to seek out and consult with an expert in the area, a cardiologist. And again, whether you're dealing with a first-party claim or a third-party insurance claim, I would recommend in any significant situation to consult with an expert and seek the guidance of an expert in the area. Next slide, please. So let's take a deeper dive at this point into business interruption insurance. And as Matt will discuss during his presentation, that's where most of the disputes and resulting litigation in response to COVID-19 has taken place. So what is business interruption insurance? In essence, it's insurance that protects the insured if there's some interruption of its business leading to a loss of income. It's designed to put the insured in the same position it would have been but for the interruption. And again, for those that don't practice in the area, one helpful way to think about business interruption insurance that I found is to think of a glass of water. And when the business is operating normally, that glass is filled with water right to the brim. But in the aftermath of some event that causes an interruption, and the water level is reduced to some extent, let's say to half or entirely, business interruption insurance acts like a pitcher of water that helps to refill that glass back to the rim. It's insurance that provides a safety net for businesses. Now, one thing, again, when I mentioned earlier to do a thorough review of your policy, one thing that has been clear to me as I've been consulting with clients and potential clients is, again, there's no uniformity in terms of either the purchase of business interruption insurance or the kind of insurance that is purchased. So what do I mean? We have seen many situations where insureds, for whatever their reasons, have made decisions not to purchase business interruption insurance entirely, or to purchase only certain coverage, but not all business interruption coverage. So for example, I've seen situations where insureds have purchased insurance to protect against expense losses and extra expenses incurred in response to an interruption, but nothing to insure for the loss of income. And so again, you want to make sure when you're responding to a claim that you have a good understanding as to what is or what is not purchased. And as we'll discuss, the same applies to various exclusions that may or may not apply in response to a given situation. Next slide, please. So what is before you here is sort of a standard form insuring agreement from a business interruption insurance policy. And you'll see here the insurer is promising to pay for the loss of business income sustained due to a necessary suspension of operations during the period of restoration. And you'll see that the suspension itself must be caused by direct physical loss of or damage to property, and the damage itself must be caused or result from a covered cause of loss. And as Matt will discuss, much of the litigation that is ongoing right now in this area relates to whether or not COVID-19 has resulted in a direct physical loss or damage to property, and whether the resulting damage is the result of a covered cause of loss. A covered cause of loss typically refers to all risks of loss, meaning anything that happens unless a specific exclusion applies. So these policies are typically referred to as all risk policies, again, covering all risks except those specifically excluded. Next slide, please. So this is what I call, a business interruption insurance chain rule. You follow these steps to determine if there is or is not coverage. And again, we're going to focus here in this context on step one. Has there been a discrete event of physical loss or damage? And step four, where no exclusion applies. Again, that's where much of the litigation has taken place. Next slide, please. So as Matt will get into in more detail in the context of specific cases that are out there, much of the litigation concerning the availability of business interruption insurance is centered on this issue of, is there physical loss or damage? And very often insurers will take the position, some courts will take the position that physical loss or damage requires some actual destruction of property. And that's simply not the case. Long before coronavirus came to our shores, courts have grappled with this issue of what is meant by physical loss or damage. And it does not require physical destruction of property. So loss of use of property qualifies. Let me give you a couple of examples to make this understandable. Think about the circus and the circus coming to town, and there's a parade going down Main Street. And Elsie the elephant decides to sit down in front of the local pharmacy. No one can get in, no one can get out. There's no physical damage to any of the pharmacy's property. All the walls are intact, everything is intact. Nothing has been destroyed, but there's been a complete loss of use of the property. No one can get in, no one can get out. That constitutes as insured physical loss or damage. In another famous case, there was an oil spill, and the oil infiltrated the property and surrounded a church building. Again, the church's walls and roof and structure remained fully intact. There was no physical destruction of the property, yet the church itself was no longer useful. Nobody could use the building in any meaningful way. And the court correctly held that there was physical loss or damage. And so the argument in this situation is, does the presence of COVID cause physical loss or damage, even though there arguably has been no destruction of any insured property? Matt will go into a bit more detail during his discussion. Next slide, please. Very often, business interruption insurance comes with various coverage extensions for event cancellation, civil or military authority interruption, the inhibition of ingress, egress, and contingent business interruption. And we'll discuss each of these in turn. Next slide, please. So event cancellation, as you could imagine, probably the most important type of insurance in connection with COVID-19. It's purchased by businesses that are going to, that are planning for and hosting events, and they want to protect against a situation where, like this situation, the event needs to be canceled. And so think about, and probably the biggest example, the Japan Olympics that were supposed to be held this past summer. I understand just anecdotally that there was maybe $800 million of insurance purchased by the IOC to protect against the very sort of event that occurred. And you can imagine the hotels, the restaurants in the area where the Olympics were going to be held also had significant claims, and hopefully they purchased the requisite insurance to protect against what eventually occurred. Next slide, please. Interruption by civil or military authority. Again, thinking about what occurred in or about March, where in response to the coronavirus pandemic, states around the country issued orders requiring the closure of buildings, the prevention of access, the very lockdown, as we saw at the beginning, and requiring 95% of Americans to stay at home at one time or another. And so this insurance protects against that very eventuality, that there's been some prohibition of access by order of some governmental authority. Next slide, please. Ingress egress is very similar to the insurance provided by interruption by civil and military authority, and it applies when ingress egress is prohibited by something other than an order by governmental authority. Very often, when a hurricane hits, roads will be closed. They'll be down, even though a particular building, the building that you would want to access, has not been damaged directly. You're unable to get to that building. Next slide, please. Contingent business interruption protects an insured when there's been an interruption of business at a customer or supplier location. Next slide, please. The one unifying theme with respect to all of these coverage extensions is that the loss itself typically needs to be traced back to, as we discussed earlier, a covered cause of loss. Again, that is a loss, a risk of loss, except for something that is expressly excluded. So for example, for any of these coverage extensions that we've discussed, if the cause of the loss is traced back to something that is excluded, you're not going to be able to recover, even though you have insurance for these various extensions of coverage. Which brings us to the next slide, Krista. In this case, when we're talking about COVID-19, the exclusion that is implicated most often and most directly is an express exclusion for either virus or bacteria. What I've reprinted here is an exclusion that is arguably the most restrictive form and one that is found most often in those insurance policies that have exclusions. And Krista, if you go to the next slide. This here is an explanation of the virus or bacteria exclusion that was drafted by ISO back in or about 2006 and was presented to state insurance bodies for the purpose of securing approval of the exclusion. And it was drafted, I believe, in response to the SARS outbreak that was occurring at that time. But you can see that the insurance folks were somewhat forward thinking, and they saw the specter of a pandemic. They understood that something like what is happening now could happen. So they were somewhat prescient um, in planning for and drafting their insurance policies. And a lot of the litigation that is occurring at the moment centers on various types of exclusions. Now, again, insurance policies are not uniform. Some policies may contain exclusions expressly dealing with virus or bacteria. I've seen others that just don't have an exclusion. And I've seen many different forms of exclusions. In one example, a potential client had a policy that contained an exclusion applicable to microbes. And microbes are living things. It turns out a virus, the coronavirus, is not a living thing. And so arguably that exclusion wouldn't apply. And so, I think as Matt will discuss in a bit more detail, what we're going to see in these cases that are being litigated, they're going to turn on one, does the policy have an express exclusion for coronavirus? And two, if it has an exclusion, does the exclusion apply to COVID-19 claims? Or much like the microbe exclusion that I just mentioned, does it apply to something other than coronavirus? And then finally, taking us back to the beginning where I mentioned, my involvement in insurance coverage for environmental claims. Much of the litigation that spanned over 20 or 30 years dealt with a dispute over whether a so-called pollution exclusion was enforceable by the insurance industry. So the exclusion itself was drafted in 1973. And at that time, or in the years preceding that, the insurance industry through ISO went to state insurance regulators with an explanation of the exclusion. And it's eerily similar to the explanation offered by the insurance industry with respect to the virus or bacteria exclusion, in that the insurers represented to the regulators that there wasn't insurance coverage currently available under current policies, and the exclusion, the pollution exclusion, was offered to clarify that intent. And some courts concluded that that was a misrepresentation. And as a result, they stopped the insurers from enforcing the pollution exclusion. And I know that lawyers that represent policyholders are crafting very similar arguments around this sort of explanation that was filed with state insurance regulators concerning the virus or bacteria exclusion. So I think, as some of these cases unfold, you're going to see that same issue, what's called regulatory estoppel, being litigated through the courts because obviously billions and billions and trillions of dollars are at stake. And with that, I'm going to turn the proceedings over to Matt, who will give us further insight into some of the litigation and legislation that has been spawned as a result of COVID-19. Matt?
Thanks so much, Lee. My name is Matt Goldstein. I'm also one of the insurance recovery attorneys. Perfect. Well, welcome back. Sorry about that. I think the Zoom gods were not looking fondly on us today, but we're back now. My name is Matt Goldstein. I'm also one of the insurance recovery attorneys at Flaster Greenberg. My background is not only in insurance recovery litigation, but also securities and business litigation. And as Lee talked about, I'm going to focus this presentation, or on my section of the presentation, more on the current state of litigation involving business interruption claims, as well as proposed legislation that's sitting out there right now. Next slide, please. Next slide, please. So just a general overview of the landscape of business litigation. Right now, there's been over 1,200 lawsuits filed since the beginning of, or mid-March. And most of the states have, at least a few business interruption lawsuits, but, the heavily populated states that have at least 50 lawsuits and more, some have 100. California is big, Florida, Pennsylvania, Texas. And that you can kind of see the curve in this illustration of, starting in the beginning of the pandemic to now, the cases just continue to increase. Next slide, please. And this is a good illustration of the policyholders. Most of them, as you can expect, are in the food and beverage industry. I think one of the industries that has, hit the hardest, given that they've had to close and couldn't operate any type of business, really no revenue at all. And some of the notable plaintiffs and policyholders that have filed suits so far, the Houston Rockets, certain minor league baseball teams. There have been a few Las Vegas casinos, including Circus and Treasure Island. One of the big department store chains, Century 21, that actually came out and said that they are filing for bankruptcy specifically because the insurance company denied their business interruption claim. Ralph Lauren has filed, In-N-Out Burgers, and recently Outback Steakhouse was a big chain to file suit. Next, please. And this is just an illustration of insurance companies, lawsuits by insurance company, Hartford being one of them, Cincinnati being another one, so on and so forth. And one of the things that's great is a lot of these illustrations are from the University of Pennsylvania Law School put together a COVID-19 litigation tracker. And I urge everyone to check it out. You can just Google it. And it has a bunch of these illustrations and really does a great job of tracking the litigation, not only business interruption, but also all types of claims relating to COVID-19, whether it be employment, liability, as John will talk about, but the big one, business interruption insurance. Next, please. And again, another illustration really shows that the bulk of cases are brought under, business income or business interruption coverage grants. Also, civil authority and extra expenses Lee talked about. And again, ingress, egress, contamination. Some of them premium relief. There have been policyholders that have sued claiming that their premium should be lowered because their businesses have not been open, and so the risks are a lot lower. Next slide, please. And this really gets into the meat of what I'm going to present. Is there's been about 31 opinions so far in business interruption claims. Out of those 31, 11 have found for policyholders and have actually denied the insurer's motion to dismiss. I'll go over a couple of them that have been, the first wave of decisions, and ones that both policyholders are citing frequently in oppositions to motion to dismiss, and insurers are trying to distinguish in their motions to dismiss. So the first one is a case Studio 417 versus Cincinnati Insurance Company. It was brought in the Eastern District of Missouri, and the policyholders are a bunch of restaurants and hair salons. And one of the things that distinguished this case and why the court actually denied the insurer's motion to dismiss is because the policyholder alleged the presence of COVID-19 at the property. And you can see by the quote, even though they don't have direct evidence of it, upon information and belief, it's likely that visitors and or patrons, employees who were infected with COVID-19 have actually entered the property. The court took the phrase direct physical loss and used ordinary dictionary definitions of the term direct, meaning characterized by a close, logical, usual, or consequential relationship, physical, having a material existence, and loss, the act of losing possession or deprivation, and found that the fact that COVID-19 was likely at the property, that the policyholder sufficiently alleged a direct physical loss to the covered property. And one of the important things is the court actually recognized, and something that Lee talked about, was that you can have a direct physical loss of property without a physical alteration to the property, such as fire damage. And the insurance industry is, of course, trying to distinguish this case, saying that most states' law requires a physical alteration of property, and that even though this case beat the motion to dismiss, as they get into discovery, the policyholder will likely be unable to establish that COVID-19 was at the property, or the fact that it could have easily been wiped off the surfaces, and therefore the damages were, there were essentially no damages at all. Next, please. Again, 2017, and the court essentially adopted the reasoning. The optical service case is a case that was recently decided out of New Jersey State Court. And one of the interesting things in this case was that even though there were no allegations of COVID-19 at the property, the policyholders relied on New Jersey case law, which I'll get into a second, which is, reiterates that you don't need to have a physical alteration of the property to have, a covered cause of loss. And the court said that this argument is actually interesting, and the fact that, New Jersey law has not analyzed the direct physical loss requirement in the context of COVID-19, that they wanted to afford the policyholders the opportunity to engage in discovery and see if they can, sufficiently prove a direct covered loss to property. Next, please. Again, another one was a Blue Springs Dental. It was out of another Missouri case. It adopted the same definitions of direct physical and loss as the court did in Studio 17, and said, and denied the insurer's motion to dismiss. And one of the phrases that policyholders are really, think the court got it right was, plaintiffs plausibly allege that COVID-19 physically attached itself to the dental clinics, thereby depriving them of the possession and use of the insured properties. And as Lee talked about, one of the ways to show a direct physical loss is the loss of use. And then the last case, the court specifically analyzed a virus exclusion. Now, it wasn't your typical virus exclusion, an ISO virus exclusion that Lee talked about, but it had to actually deal with, the wet rot, dry rot, fungus exclusion. And you can see the language of this specific exclusion. And while it includes the word virus, the court found that the exclusion was ambiguous because putting virus next to the words fungus, wet rot, dry rot really didn't align with the grouping of an actual virus exclusion, meaning that, a fungus or wet rot or dry rot are actually physical properties to, say wood, for example, where, a virus as COVID-19 really doesn't logically align itself with that exclusion. So the court denied the motion to dismiss and allowed the insured to proceed with discovery and possibly a summary judgment motion. Next slide, please.
Hey, Matt.
Yes.
While the slide is being advanced, based on your review of these cases, what would be the optimum way or the best way for an insured to establish physical loss or damage?
Yeah, that's perfect. And I'll get to that. I have two slides right after this where I'll show some actual language that policyholders have used in complaints and have been successful in specifically alleging direct physical loss or damage to property.
Great.
But thank you, Lee. It's a great question. Out of the 31 opinions that have been issued so far, 20 of them have found for insureds, or for insurance companies. And some of the reasoning that the courts have found in those cases was they've equated direct physical loss or direct physical damage to an actual physical alteration to property, such as fire damage, wind damage, and so forth. And in most of these cases, the policyholders have failed to even allege that COVID-19 was at the property or there was the imminent threat that COVID-19 could possibly enter the property. Also, there's been no permanent disposition of the property, meaning that although they might have been closed by civil authority orders, when they were lifted, the policyholders were able to open their restaurants and operate as normal. And again, as Lee talked about, insurance companies have relied specifically on virus exclusions, both the one that I talked about earlier with the wet rot, dry rot, but also your typical ISO exclusion. Next slide, please. And some of the seminal cases that courts have relied on, and both policyholders and insurance companies have relied on, are outside the context of COVID-19. But as Lee talked about, showed a specific loss to the property, whether it be a loss of function or a loss of use. And so some of those cases, one of them being the Port Authority case, it's a Third Circuit case which has been which is often cited. And the court found that the presence or imminent threat of the release of asbestos constitutes physical loss or damage because the function of the property would be eliminated. But in this case, there was actually a release of a gas in the property similar to COVID-19 being a virus in the property. There's an interesting case, Murray versus State Farm out of the Supreme Court of West Virginia. In that case, there were 3 homeowners who owned homes at the base of a high wall at an adjoining quarry. Rockfall from the high wall damaged 2 of the 3 homes, but one of the homes was not actually physically damaged. But the court found that all 3 of the homes experienced direct physical loss because it became clear that rocks and boulders could, the imminent threat that they could be damaged. Another one, which is out of New Jersey, and it's one of the cases when the court, the New Jersey case relied upon it. It's Wakefern. It's not up here, but it had to deal with food spoilage at a ShopRite facility as a result of a 2003 blackout. The insurer attempted to deny coverage, saying that there was no physical damage to the property owner's own power equipment, but the court found that there was, the power grid was physically incapable of performing their essential function, and therefore equated that with direct physical loss. And then, a recent case finding for the insurance company, but, but insurers are, relying on it often, is a case out of the 11th Circuit, Mama Joe's versus Sparta Insurance. It had to deal with, the court found that there was no physical loss or damage to a property where dust from a nearby construction site entered the property, but the court found that the function wasn't altered. But really, the distinguishing factor in that case was the restaurant never closed down, and it just had to deal with debris, not something specific as a virus entering the property and actually shutting it down. But, insurance companies are relying on it, and it's a hot button topic right now in cases that are brought, pursuant to Florida law, whether Mama Joe's, an 11th Circuit case is binding or controlling. Next slide, please. And so to get back to Lee's question, how are policyholders actually alleging, or sufficiently alleging, the presence of COVID-19 at their property, or specific alleging a direct physical loss in complaints? And there's really 2 ways to do it. One is direct evidence. You have someone come out, you test the property, and there's actually the presence of COVID-19 on the surface. Most policyholders, probably did not have that done. And so really it's the circumstantial evidence. As I talked about, certain employees or patrons tested positive for COVID-19 both before or after being present at the property. And as you can see in the Circus complaint, it was this specific allegation. They actually alleged that persons infected with COVID-19 were present at the property prior to when the government issued a shutdown order closing the casino. Next slide, please. And so even if a policyholder can allege or has knowledge that someone infected with the virus was at the property, one thing that policyholders should consider is alleging the imminent threat of COVID-19, just like the case, the West Virginia case, where the imminent threat of the boulders causing an impact to the property, or the release of asbestos or ammonia in the air was an imminent threat. That the virus being in the community, it's ubiquitous. There's an imminent threat that COVID-19 has damaged the property. And as you can see, this is one of the allegations in a complaint that sufficiently, or at least that alleged the imminent threat. And again, another takeaway is policyholders should also carefully analyze applicable exclusions. As Lee talked about, you might have a typical ISO exclusion for viruses, but then again, in the New Jersey case, you had an exclusion that referenced the word virus, but the court found that it was ambiguous and allowed the case to proceed. So not every policy is uniform, not every exclusion is uniform. So it's really important to analyze each exclusion before filing suit. Next slide, please. And just a quick overview of current legislation. It's all proposed legislation. 10 states and the District of Columbia have introduced legislation that will require specific businesses, a specific business interruption policy to cover claims for small businesses, even if it contains an exclusion here are some, two bills, introduced in PA and one in Jersey that have certain requirements, as well as the PA bill really redefines property damage, kind of in line with what we've been talking about, even though, not saying that it needs to have a specific physical alteration to the property. Next slide, please. And again, there's some federal legislation out there. Nothing has been passed, and given that it's an election cycle, likely that nothing gets passed anytime soon. But one of them being the Business Interruption Relief Act of 2020. It was introduced by Republican Mike Thompson, a Democrat out of California, and essentially create a voluntary program called the Business Interruption Relief Program that would reimburse insurers who voluntarily pay out business interruption claims. There's really not much to it on how it's being funded, but the bill has at least been introduced. The second one that kind of has some more meat on its bones is the Pandemic Risk Insurance Act of 2020. It essentially establishes a pandemic risk reinsurance program within the Department of Treasury. It would apply to the outbreak of infectious diseases moving forward, meaning after January 1st of 2021. And it would have certain limits on it. It would only kick in if aggregate losses, insurance industry losses exceed $250 billion, and then has a cap of $750 billion. And insurance companies would have to meet a deductible before the federal government would kick in any type of reimbursement. And the last one being the COVID-19 Business and Employee Continuity and Recovery Act. It's essentially a relief fund for small businesses that would be administered by the Department of Treasury, and it would fund businesses and policyholders that have suffered losses in connection with COVID-19. Next, please. And again, just some key takeaways. I think it's really important that review policies in full, although certain insurance companies have been involved in, hundreds of suits. Not every policy is the same. So it's really important to read the policy in full and analyze each coverage grant. And, insurance companies are uniformly denying every claim across the board. I've only actually seen one or two insurance companies that have actually accepted coverage in connection with pandemic coverage, not business interruption coverage. But just because the insurance company denies the claim doesn't mean that you have a viable claim or a policyholder has a viable claim. Again, proper pleading is probably key. As you can see from the cases when the policyholders allege the physical or the presence of COVID-19 at the property, it has survived a motion to dismiss. And again, consult experts, whether it's brokers, coverage attorneys, to really understand the coverage grants, but also prior to a policyholder's next renewal cycle. No one could have expected the losses that were sustained as a result of COVID-19, or that even insurance companies would deny every claim. Policyholders would think if they have business interruption coverage, a pandemic like this would be covered. But it's something that policyholders should consider in their next renewal cycle. And it's also, who knows if the insurance company will draft a pandemic exclusion similar to the virus exclusion from the SARS outbreak in 2006 that would eliminate, all coverage in connection with a, COVID-19 or coronavirus outbreak, and whether, if that's going to be standard in policies and how much policyholders will have to pay in premiums to have that removed from a policy. So it's really, up for discussion, and it's a fluid situation. And so we'll see how the insurance company and policyholders respond. And that is it. And I will turn it over to John.
All right. So good afternoon, everybody. I think the first question that we need to ask, which is a question directed to Matt and Lee, is there CLE interruption insurance coverage for the lost time from our technical glitch?
John, as you well know, you've got to review your insurance policy.
I will credit that to one of our ingenious lawyers in the group. I laughed out loud when I saw that one. Mm-hmm. So before I get started, there's only one other thing I have to say, which is to jibe Lee a little bit because I can't help myself. So I recently had a son, not a daughter. So those of you that know me, don't worry. Nothing crazy happened. All right. So there wasn't a daughter on top of the son. Okay.
Congratulations.
Thank you. Thank you. Okay. So I am John Cook. I am a shareholder of Flaxter Greenberg, and I'm also in the insurance recovery group, in addition to the real estate and environmental group. And as Lee had mentioned, I am going to touch on liability insurance. So Krista, can you bump us to the next slide? All right. So Matt and Lee spent a lot of time talking about business interruption insurance, which is part of a property insurance policy and involves the insured's own economic loss. And we're gonna shift focus now. Now we're going to start talking about what happens if I get sued, right? From a business's or policyholder's perspective. What if I get sued? Is there insurance coverage for that? Okay. So what we're going to talk about are, well, what's happening out there? What liabilities are taking place? What lawsuits are being filed? And what is being alleged? And then we're going to take a look at, all right, well, what liability insurance coverages are available and might exist that might respond to those lawsuits. So Krista, can you bump us to the next slide? All right, first let's start with some fun stats. Based on the stats compiled by a group that tracks this stuff, there have been about 5,500 civil lawsuits filed nationwide to date, or recently, involving COVID-19 in some way. So this is just civil litigation generally. It even includes insurance coverage lawsuits. And of that, roughly 700 involve potentially insured claims. That means, in many cases, somebody contracted the disease, suffered harm, and says somebody's responsible for my injury. And the nature of those claims have involved wrongful death, bodily injury, property damage, employment-related claims, and various other types of claims that you see there. So another just fun stat, which is not surprising, almost a third of all civil lawsuits that are connected with COVID-19 in some way have been filed in the tri-state area. Specifically New York, New Jersey, Pennsylvania, which I guess is not surprising in the sense that, you know, this area has really been hit quite hard by the pandemic. But you know, it just illustrates where a lot of the meat of this is. And anecdotally, the word on the street is, you know, we have 5,500 lawsuits now. Word on the street is there could be a whole wave, right? This, Lee prognosticated earlier that, you know, we're not sure whether this is going to become something like another asbestos or whether it will peter out. But there are certainly those of the view that there is a lot more to come. Okay, so next slide, please. Oh, by the way, I know that it's about quarter after. I'm not sure what the interruption, what impact the interruption has on my time. So I'm going to truck through and try to leave time for some questions. And Lee, feel free to interrupt me if you feel like we should cut it off and allow for some questions. All right, so generally speaking, you know, so there are roughly 700 civil lawsuits out there alleging some kind of harm from COVID-19. What are the legal theories that are being alleged? And what we're seeing, some examples are your basic negligence claim, right? Negligence that resulted in exposure or increased risk of exposure to the disease. Intentional torts, willful conduct, or reckless or wanton type conduct. Public nuisance claims, which is an interesting one that we'll get into in a minute. And also workplace discrimination and harassment, retaliation type claims. So what are some of the fact allegations? Those are legal theories. Those are types of claims. You know, what are plaintiffs actually saying? Just some examples generally. Failure to follow regulations or guidelines from authorities like OSHA or the Center for Disease Control. Failure to properly or reasonably minimize the risk of exposure. Failure to implement policies and procedures regarding social distancing. Failure to provide hand sanitizer. Failure to provide opportunity for cleanliness. Failure to institute engineering controls and monitor the ambient air quality in a building. Failure to warn of potential exposures or the potential presence of the virus at a property. Providing misleading or inaccurate information about the disease and its risks. These are all fact allegations that have been lodged in some of these lawsuits, generally speaking. So that orients us a little bit. Okay, so what are we seeing out there? Importantly, these are some examples. These are not exclusively what has been alleged and what might be alleged. But what this does tell us is that probably the majority of civil litigation that we're going to see is going to center around exposure, right? Exposure to the disease and harm as a result of contracting the disease. So next slide, please. All right. So the next few slides, the next 3 slides, focus on specific lawsuits that have actually been filed, just so we can take a look at some concrete examples. And I'm pretty sure, well, I know all 3 of these lawsuits that I'm going to discuss have been in the news, and some of you might be familiar with them. So the first is Evans v. Walmart et al. So here, a Walmart employee, Evans, contracted COVID on the job and passed away. And his estate brought a wrongful death claim against Walmart and also against Walmart's landlord. First, let's take a look at, for the sake of clarity and ease, I'm just going to say Evans, the employee. Let's take a look at the allegations that Evans lodged against Walmart, his employer. He says Walmart acted negligently, willfully, and wantonly because it ignored employees who said they suffered COVID-19 symptoms and allowed them to keep working. Now remember, these are allegations. We don't know if they're true or they're not, but this is what's alleged. Evans says that Walmart didn't disinfect the store or provide employees with masks, gloves, or other personal protective equipment. Didn't implement or enforce social distancing guidelines. Failed to evaluate employees for symptoms. For example, taking temperatures and things of that nature. Failed to properly screen new hires to make sure that risks weren't being let into the property. And didn't follow various CDCP, Center for Disease Control, guidelines regarding a disease response plan and infection prevention measures, providing desanitization equipment, etc. So pretty similar to what we saw on the previous slide. Effectively, what's going on here? They're saying you were negligent and wanton and recklessly disregarded my well-being by failing to do these safety precautions and properly address the virus. And that resulted, or at least contributed, to me getting sick and suffering harm. And that's the gist of it, right? So let's go to the next slide, if you would, Krista. Krista. All right. Okay, now what about the allegations against the landlord? So remember, we just spoke about what Evans said against his employer. Now, what's he saying against the landlord? He's alleging that the landlord acted negligently by failing to close the Walmart Supercenter and the adjacent businesses, and that it should have known that keeping them open posed a greater risk of the disease spreading. The landlord failed to inspect or clean or sterilize the building and surrounding buildings. failed to impose relevant guidelines, failing to implement various controls. Pretty much the same stuff against the landlord, right? Now, again, these are allegations, right? Many of you may be thinking, well, wait a minute. In the beginning, you know, it was not clearly understood what had to be done. Importantly, we're not talking about the merits of the allegations. We're talking about what they are, because this presentation doesn't focus on whether businesses might be liable. It focuses on whether they have insurance coverage if they're sued and potentially could be held liable. Okay, so let's go to the next slide. So that's the Evans lawsuit. Now, this is a little bit of a different type of situation. Many of the same fact allegations, but different relief. So this is a class action lawsuit brought in Illinois by various McDonald's franchise employees and their families. And the class action is against McDonald's Corp, in addition to the actual franchise companies. So, and that is an important distinction that we'll get into in a little bit in terms of the interplay between liability, workers' comp, etc. So little teaser. So what are the allegations? Essentially the same kind of thing, right? They forced workers to be in close quarters, to work in close quarters, and failed to create procedures for social distancing among workers and customers. Failure to provide adequate protective gear, force employees to reuse dirty face masks and gloves, gag orders, don't tell anybody you got sick or you think somebody else is sick, no hand sanitizer, it's a tricky one, no safety training, providing inaccurate information about the risks, all the same kinds of allegations. But it's not a negligence claim, right? They're not saying I was harmed. They're saying McDonald's and franchisees, you created an unsafe working condition and increased the risk of the spread of the pandemic, and consequently the risk that I'm going to get it and the public at large is going to get it. Therefore, you have created a public nuisance, which is a tort, right? So the claim here is public nuisance. They're not saying I got sick and suffered damages. They're saying you created a public nuisance. So different, right? I will again touch on this a little bit later, but just as a quick comment, what's the exact relief that they're seeking? Okay, well, if they created a public nuisance, what does McDonald's and the franchisees have to do? Well, they have to take steps to remedy the situation and make a safe working environment and get rid of the public nuisance, which does sound a lot like injunctive relief, right? You have to do something. You don't have to pay me money, but you do have to do something and incur costs in doing something. All right, so that is Tay Narvis. Now let's jump to the next one. Next slide, Krista. All right, thank you. Okay, Douglas v. Norwegian Cruise Lines down in Florida. Again, this was in the news. So here we have kind of a very different type of lawsuit. We're not talking about exposure liability. I got sick or I might get sick because of what you did. This is an investor securities class action brought against Norwegian Cruise Line and its CEO and CFO, alleging that they, the defendants, made false statements in SEC filings and engaged in various other activities that created a false, put the company in a false light, falsely inflated the value of the shares in the public's perception. It's my inartful way of making that point, but you get the idea. So specifically, the allegation is that Norwegian, the defendants, made false statements in their filings about their strong performance despite the coronavirus outbreak and how clear or obvious it seemed that, boy, maybe cruise lines aren't the thing to do right now, right? And portrayed confidence in their ability to operate and be profitable with safety measures, even though, you know, history tells us nobody's going on cruises right now. In addition, there's the allegation that they engaged in deceptive sales practices and to try to increase sales in a point where they are just not likely to happen. So all said and done, essentially what's being argued is you made the company look better than it actually is. You made misleading statements. And if I had known that, I would have never bought the shares. And that's what the stockholders allege, the class of stockholders. So that's looks a lot like, you know, it's a securities class action claim, and it looks a lot like a D&O type claim. Very different than what we saw earlier. Another quick anecdote, you know, the chatter out there is that experts think there are more of these coming. Experts think that there could be a wave of mismanagement D&O type claims connected to the pandemic and how companies and their management handled the pandemic and the perceived resulting financial loss to shareholders. So we shall see, but here's one at any rate. Okay, so next slide, please. All right, so we took a look at the kinds of lawsuits that are percolating out there, the types of the allegations that are being made, the nature of the claims being made. Okay, got it. Now, what if it happens to me? Do I have, as a business, do I potentially have insurance for this? And the answer is maybe. We think that in many instances, there very well could be insurance. So repeating the mantra, make sure that you understand your coverage program, that you read your insurance policies, and that, you know, you accept the fact that you and your insurer are likely to have a very different point of view on whether something is covered. So with that aside, right here is a list of potentially applicable coverages that might apply to some of the lawsuits and risks that we've identified, and some that we might be able to think up that might be coming down the pike. This is not necessarily an exhaustive list of liability insurance coverages that could apply in any situation, but I think this gives us a good overview. So we have typical general liability insurance, we have workers' comp and employers' liability insurance. And before I move on, I want to tell you, I'm going to spend the majority of my time, perhaps all of it, depending on how much time we have, focusing on general liability with a little bit of workers' comp and EL thrown in, because I think that probably has the broadest applicability, generally speaking. And it provides a good base for understanding how to think about this, right? But there are other forms of coverages that may absolutely apply in various situations and that ought to be considered. Pollution legal liability, directors and officers, employment practices liability, and professional liability insurance. So I'm going to discuss very quickly each one of these types of insurance. This, again, is a broad overview. These are complex policies. They are complex concepts. They are wonky, and this is why there's so much insurance litigation out there. But 30,000-foot view. Okay, Krista, go. All right. So for folks that are familiar with insurance, this is maybe a little bit overkill or underkill, as the case may be. Essentially, what does general liability insurance cover? Right? Commercial general liability policies, business owners liability policies, what virtually every business buys in some form or fashion. Here is an example of policy language that may apply. Not all general liability policies are the same. Not all have the same language. Okay, having said that, The language is, we will pay those sums that the insured becomes legally obligated to pay as damage because of bodily injury or property damage to which this insurance applies. We will have the right and duty to defend the insured against any suit seeking those damages. Okay? So we'll pay your damages, we'll indemnify you, and we'll also defend you if the damages fall within the coverage, or could fall within coverage. All right, so what we need to know, what does that apply to, right? It applies to bodily injury and property damage caused by an occurrence. And bodily injury is, at face value, pretty self-explanatory. Your hand gets chopped off, that's bodily injury. You get sick from COVID-19, that's probably bodily injury. Bodily injury, sickness, or disease sustained by a person. Property damage, physical injury to tangible property, okay? I'm not gonna focus so much on property damage right now. I'm gonna focus on bodily injury, but similar concept. Okay, finally, what is an occurrence? It's an accident, including continuous or repeated exposure to substantially harmful conditions, substantially the same harmful conditions. An accident, right? An event, something that happens that is not expected, but it could happen, and that's why you buy insurance coverage for it. So that's just a very simplistic explanation. So that's what is covered. That's pretty broad. That's a pretty broad coverage grant, right? If an accident happens that causes an injury, you probably, and somebody gets hurt and sues you for it, you might have insurance for that. There probably is. Next slide, Krista. Okay, but there are some clawbacks in the form of exclusions, right, that might negate coverage that otherwise would fall within the coverage grant. The virus exclusion, we've already discussed that. That exclusion may be in general liability policies. It may not be, but it may be, and it has to be considered. Everything that Lee discussed applies. Fungi microbes, same idea. Pollution exclusion, same idea. Actually, Lee did a great job in covering a lot of that. The expected or intended exclusion and workers' comp employer liability exclusions. These are all exclusions that we can expect insurance carriers to raise to get out of providing liability coverage. So Lee spoke about the pollution exclusion right on the money, right? It may, that exclusion may or may not apply, right? There is case law out there suggesting that the pollution exclusion is really intended to apply to traditional environmental losses and liabilities, like oil in the ground, not necessarily microbes or fungi or other pollutants and contaminants in the ambient air. So just because the insurer launches the pollution exclusion as defense doesn't mean you're out, okay? Expected or intended, that's another one. Insurers might say, well, you're the one that refused to follow CDCP guidelines, so you should have expected or intended that there would be an increased risk of spreading the disease. So sorry, excluded, no coverage. We can expect insurers to raise that one. That's probably more of a tough road to hoe in many instances, and insurers bear the burden of showing that an exclusion applies, but we can expect to see it. Finally, the workers' comp and employers' liability exclusion. What's the easiest way to say this? Essentially, general liability isn't supposed to apply if you get sued by your employee. Different insurance may apply in that instance, but not general liability. And that's what this says. So Walmart, well, before we get there, so there is variation, no assumptions, read your policies. Okay, next slide, Krista. So quick redux. Let's take a look at Evans v. Walmart again. So Evans' suit and Evans' claims against Walmart, would there be CGL coverage, general liability coverage? Yeah, probably not. that employee exclusion will probably apply and knock that out. But Walmart I shouldn't say even Walmart, workers' comp and or employer's liability may apply. And we're going to get into that when we talk about workers' comp insurance. But I wanted to draw that distinction here. General liability, probably not going to apply. Well, what about Evans' claims against the landlord? Well, Evans is not a landlord employee, so the landlord may well have liability insurance covering it for Evans' claims. I don't know, but it looks like it may in fact exist. We'll find out. Okay, let's take a look at the McDonald's Corp lawsuit. So we had discussed McDonald's. Sorry, 1 minute here. Right, I know we're running out of time, so I will try to speed this up a little bit. Okay, so McDonald's, the class action against McDonald's by the employees and their families. Well, McDonald's filed a coverage action against its liability carrier, McDonald's Corp, that is. Does it have coverage? Well, it might, because the franchisee employees are not employees of McDonald's. So that general liability may indeed imply. Of course, the carrier, Austin Mutual, saying, well, no, I don't owe you coverage. There's no bodily injury. This doesn't even fall within the coverage agreement. This is a public nuisance claim. They're asking you to take steps to create a safer work environment. Where's the bodily injury? My general liability policy doesn't apply. Now, is there coverage? We don't know. But that motion to dismiss was filed like 2 days ago, and we'll find out what happens. Quick aside here, this is where coverage counsel can be very useful, right? If I were McDonald's coverage lawyer, I would say, you know what? Public nuisance and the necessity of creating safe, taking steps to create a safer work environment, testing employees, testing customers, monitoring customers and employees, tracking the spread. That sounds a lot like medical monitoring. And guess what? Medical monitoring in the environmental toxic tort world. Guess what? There is authority out there that says medical monitoring constitutes damage caused by bodily injury and therefore may be covered by a general liability insurance policy. So, the law is certainly not settled in the land and may apply differently in different areas, but it's important to understand that just because it doesn't nicely fit in the square box and the insurance adjuster says, I don't know, doesn't mean you don't have coverage. It's important to be creative. I would absolutely argue that the relief being sought here is akin to medical monitoring and constitutes damage for bodily injury. All right, next slide. Workers' comp. Okay, so I'm gonna jump kind of right into the takeaway. So workers' comp is a product of statute in all 50 states. And essentially it says this: if an employer provides a workers' comp benefit to its employees, it enjoys statutory protection from lawsuits by the employee. And in return, the employee obtains the benefit of workers' comp insurance. It gets coverage for its medical expenses and lost wages and certain other forms of losses. And the advantage to the employee is it doesn't have to prove that the employer is at fault. It doesn't have to, which means it doesn't have to sue the employer and prove that the employer was negligent, for example, in order to obtain a benefit. It makes the workers' comp claim and obtains the benefit right away, which in many cases works. You get hurt on the job, you get your workers' comp. Okay? Well, here's the big question, right? Workers' comp does not apply to all injuries, particularly all diseases. It applies to occupational diseases. And the big question is COVID-19 an occupational disease? That is to say, is it a compensable injury under workers' comp insurance? And many, many businesses are very interested and perhaps confused by that question. And I regret to say, you're not going to get an answer today because nobody knows the answer yet. That remains to be determined. Here's some rules of thumb. An occupational disease is generally compensable if it arises out of and in the course of employment, of the employment of the employee. So if you are a doctor working in a hospital and you contract COVID on the job, all right, well, that happened during the course of employment. And you know what? Maybe it does arise out of the nature of that employment. I mean, that's what you do. You're a medical provider. You're on the front line of treating communicable diseases. So that might indeed apply. But what about Evans, the Walmart employee working on the retail floor? Is the nature of his work really connected to contracting COVID? Isn't that the same thing as the flu or the common cold? What about his work makes that an occupational disease? And I will tell you that common communicable diseases like the flu and the common cold do not fall within workers' comp coverage. So this is an issue that is going to bear out, and it's going to depend on the facts of the situation, the nature of the employment, and the state in which the facts have occurred, because different states' programs and laws vary. Krista, can you bump us to the next slide? All right, Evans v. Walmart read-down. So that's what I had just explained. We don't know, right? What happens if it's not an occupational disease and is not covered by workers' comp? We already know that you're out for general liability insurance. Are you done? Not necessarily. That's where employer's liability coverage may come into play. It's often called Part 2 of workers' comp coverage. And not necessarily every workers' comp policy has it. You got to pay premium for it, but many do. And that's where that may come into being. It may also come into being where an employee alleges willful or reckless conduct, kind of like Evans did here. Sometimes an employee may do that to try to get around the workers' comp limitations. All right, so that next slide, Krista, please. All right. So that kind of covers the basics. We saw where the gaps are and how those gaps get filled, right? No CGL coverage for suits by an employee, but workers' comp might step in along with the concomitant liability protection provided by workers' comp legislation. And if that doesn't apply, well then employer's liability might apply if you have it. And it might, right? That requires a detailed analysis. So in this area, it must be mentioned that various states have proposed legislation or enacted legislation creating a presumption that COVID-19 is an occupational disease, a rebuttable presumption that it is an occupational disease, therefore providing employers with the liability protections of workers' comp programs, and also, providing employees the resulting workers' comp benefit, but that workers' comp benefit is limited, right, to medical expenses, lost wages, things like that. Not going to include punitive damages and things, and loss of consortium and other various things like that. New Jersey, just last month, enacted legislation. It is in effect creating the presumption. Pennsylvania and New York have legislation pending, as do many other states. Of note, the presumption only applies to certain occupations that make common sense, right? Occupations that by their nature are on the front line of this pandemic, and by their nature may result in an increased risk of exposure. All right, so next slide, Krista. What time is it? It's about 1:46. So I am going to very quickly name these coverages and then stop because I think we're pretty much out of time. But I want to say this, all right? Directors and officers coverage provides coverage to the officers and directors, to the company to the extent they have to indemnify their officers and directors, and to the company itself for wrongful acts, right? If they committed a Securities Act violation, misrepresentation in SAC filing, failed to properly manage the pandemic. These are all claims that might fall within D&O coverage. Our Norwegian Cruise Lines case, that might fall under the auspices of directors and officers liability coverage. Important point to note, this could be an important one. But some D&O policies have virus exclusions. Got to read them. Insurers have been inserting virus exclusions into D&O policies of late. If you didn't have one in your previous renewal and you have one now, look at the circumstances surrounding that. Make sure that it was legit because there's been some funny business going on there. So can we bump 2 slides, Krista? Okay, one more. One more. That was too many. One more. All right, keep going. So we have pollution legal liability. I don't need the slide, I can just tell you about it. So this is potentially very important coverage, although it's narrow. And it's important because it's a specialty kind of coverage. And it may, and it's less likely to have a virus exclusion because it's intended precisely to cover things like irritants, contaminants, mold, fungi, microbes, and viruses. Some PLL policies do exclude viruses, many don't. This type of coverage could be a boon for policyholders that bought it. Things to note, it only applies to specific properties, okay? So it's not broad coverage like a GL policy. But many industries have PLL policies or contractors or construction pollution liability policies. Take a look at those. All right, employment practices liability. This applies for wrongful termination claims, discrimination claims, harassment claims, etc. Envision this. You got to furlough 50 employees. All right, let's go ahead and do it. Wow, 80% of those employees were over 55. You may face wrongful termination claim. This type of coverage may respond to that. Okay, let's bump again. One more time. Professional liability. All right, generally speaking, this liability coverage is probably less likely to apply to direct COVID liabilities that we've been seeing so far, with the exception of medical malpractice. That may come into bear, or professional liability for nursing homes or ambulances or other types of first responders to the extent they have professional liability. That's where this coverage may indeed come into play. So let's go to the last slide. Let me wrap it up, and I'll blame this on the CLE interruption. Takeaways, just to reinforce it. Understand your coverage program. If faced with a lawsuit, always consider insurance. Cast a wide net. We just swept through a bunch of different kinds of coverages that may apply to any given situation. Just because you get knocked out on one coverage doesn't mean you have coverage somewhere else, right? Also, be mindful that with the exception of general liability insurance and perhaps employer's liability, most of these coverages are claims made, right? That means that a claim has to be made and you got to report it in the defined reporting period. And if you blow it, you forfeit coverage. So as Lee said, notice is important. As a esteemed colleague once said, notice early, notice often. And finally, the grand finale, don't accept the denial at face value. Seek help from your broker, your insurance counsel. Insurance companies, to quote another esteemed colleague, one Lee Epstein. Insurance companies, and John Fried. Insurance companies are in the business of collecting premiums and not paying claims. Sorry for the zinger for any insurance industry folks on the line. And with that, I know I gotta wrap it up. Thank you, everybody.
Thanks, John. I don't see any questions in the chat. I know we've run a little over because of the technical glitch. So why don't we go ahead and conclude now, and I'll thank everybody for participating. We'll see you soon. Thanks, guys.